Hello, everyone, and thank you for joining this program on collective actions in the European Union. We are going to present briefly the new directive of 25th of November 2020 on collective actions, or more precisely, representative actions for the protection of consumers, and how companies and their directors are affected. I'm Pascal Durand-Barthez, a lawyer and a member of IEFA, the French Institute of Directors, and a member of ecoDa's policy committee. My role will only to ask questions, and I will ask these questions from three experts. Emmanuel Plasschaert, who's a partner at Crowell Moring and head of the corporate, commercial, and employment practices of the Brussels office of this large law firm. Desnyder, who's an associate in the same law firm and a litigator, a member of the litigation and IP practice, and Nima Rafiee of AIG, who is in charge of the D&O, the Directors and Officers Insurance Practice for Europe, Middle East, and Africa, and is based in Munich. Collective actions, which are better known under the name of class actions, are something which worry companies and their boards, especially if they have experienced the US version of the procedure. There have already been two directives, one in 1998 and one in 2009, covering the same subjects and allowing consumers to obtain injunctions for the cessation of the prohibition of practices that were deemed to be harmful to the internal market. In the meantime, a majority of European jurisdictions have enacted legislations which go beyond the possibilities that was covered by the previous two directives, and adding the possibility for consumer to claim for damages on top of injunctions for the cessation or prohibition of practices. These legislations have been more or less successful, and there has been, depending on the countries, more or less litigation than expected, than feared by the companies or hoped for by the consumer organizations. The purpose of this program is to first address what is exactly a collective action, what are the main features of the new directives, how does it differ from the previous one, how can one anticipate that it will change things, why boards should mind about this, and what protections can boards and the companies rely on. So turning first to Emmanuel, what is precisely a collective action?
Well, a collective action could be defined as a civil lawsuit brought on behalf of individuals or entities who have suffered common injuries as a result of the defendant's conduct. And so one individual or one entity will act as a representative of that group. You know, indeed, that we are speaking in the EU rather of collective action. Now that in the US, they speak about class actions. The class actions, US style, are very well known and sometimes have not such good reputation because there are some abuses. And when we will speak about the recent EU directive, it's important to stress that in the directive, in the first provisions, there is a statement that abuses should be avoided because there were a lot of concerns about possible abuses. In the collective actions, the interests of many are gathered into a unique action with the aim of repairing or stopping a collective harm. That's, I think, the essence of the collective actions. Collective actions, well, they prevent the escalations of a lot of small procedures. And from a consumer point of view, this also means that it allows persons with smaller means, to get access to justice. In a nutshell, that's what a collective action mechanism is.
Thank you, Emmanuel. Now turning to Ellen, can we go a little bit further into it? And what is the legal framework for collective actions in the EU?
Let me start by saying that the last 20 years, globalization and digitalization have been playing a key role in the EU, as well as, of course, in other parts of the world. But because of these trends, a large number of consumers have been faced with an increased risk of being harmed by the same unlawful practice. The EU institutions were well aware of this risk and still are well aware of this risk. So from 2010 on, they started considering the introduction of a collective action system for consumers within the EU legal order. In the meantime, however, the member states, or a lot of the member states, had also started with putting into practice their own national collective regime. Some countries like Belgium, France, and Germany, they have implemented specific legal provisions that foresee the possibility of initiating class actions, while other countries like Austria do not or did not have these specific legal provisions. But what happened there is that the jurisprudential practice has developed a mechanism, a system to cope with mass claims. Fast forward, November 2020, the European Parliament and the Council finally adopted the EU directive on, I'll read it, representative actions for the protection of the collective interest of consumers, in short, the collective action directive, or the class action directive. This new set of rules introduces a harmonized model for representative actions in all EU member states. The directive aims at protecting EU consumers against mass harm by facilitating their access to justice. But how does it work? The directive makes it possible to bring collective actions against breaches of specific EU consumer laws. This means that the claims can cover a wide variety of consumer-related topics, like data protection, travel and tourism, health and energy, telecom, and so on. Not only domestic actions, it's important to note, but also cross-border actions are envisioned by the directive. The member states have now until December 2022 to transpose the directives and the rules into their own national legal order. And by July 2023, 6 months later, these new national measures will apply. Lastly, maybe important to note or to say is that although by the end of 2020, already 19 member states had their own collective action mechanism, there are still several member states that do not. But so from mid-2023, all EU countries, it will be possible for consumers to initiate collective actions, class actions in courts.
Well, thank you, Helen. We said before that there were both existing and probably future national legislations which will coexist with the European legislation. So we seem to have several layers of legislation. How are we going to make sure that they do not overlap?
The thing with the directive is it sets down only minimum standards and safeguards that the member states have to implement into their legal order. So, for example, the member states will have to designate so-called qualified entities that can initiate a collective actions. These entities have to comply with a set of criteria, like having a legitimate interest in protecting consumers, as well as having a non-profit status. But beyond these minimum obligations, the directive allows for a lot of optionality. So member states, they have a considerable autonomy with regard to, for example, the determination of the penalties for non-compliance with the directive. So what member states will have to do is they will have to implement the directive in a way that it fits in with their existing rules. So they only have to implement one type of collective action regime that meets all the requirements of the directive. But next to that, they are free to create or maintain their other regimes in parallel, and collective action regimes do not have to be regulated by the directive. So this means that some member states will really have to create a new collective action system or regime, while other member states only have to adapt just a few rules of their already existing regime. In Belgium, for example, the country where I practice, the existing class action regime already meets most of the requirements of the directive anyway. So to answer your question, the risk of any overlap will rather be small. But what is, however, important to note is that the nature of this directive results in the fact that by 2023, there will not be one single uniform European collective action regime. No. We will likely end up with a patchwork of different rules in the different member states. And so some rules will be more attractive for certain claimants than others. And with the possibility, like I said, of cross-border actions, claimants or some claimants will have the possibility to cherry pick and to choose in front of which court they will bring their class action.
So now back to Emmanuel. What does it entail? Could you give us insights about how the procedure will unfold?
Well, qualified entities representing consumers will try to either reach a settlement, which may then be homologated by court, or will bring an action before court and actually litigate. I think it's important to stress that the actions will not be brought before new EU jurisdictions or existing, but in the member states. So before the courts of the member states, and the national legislators will be free to determine the conditions to bring actions before their courts, either the judicial courts or administrative courts, as long as they comply with the, as Ellen said, the minimum obligations as set out in the directive, and, for example, provide for a recognition of a settlement agreements to reach as a result of discussions and negotiations between the consumers or the qualified entities and the defendants, or the implementation of redress and injunctive measures. The national court or administrative authority will either homologate a settlement or it will issue a decision, and measures will be ordered against the defendants. And the qualified entities are entitled basically to seek two types of measures. First one, well, redress measures, such as compensation, repair, contract termination, replacement, price reduction, etc., etc., or injunctive measures. We mean measures aiming at stopping or prohibiting practices which are deemed to constitute an infringement. The procedural autonomy principle leaves a high level of flexibility regarding the competent jurisdiction and timetable. On the other hand, there are still a lot of uncertainty because it's a directive which needs to be transposed in national law. The directive set out principles which will be implemented probably in every member state in a different way. So a lot of uncertainty, and hopefully we will have more clarity in the coming years when each member state will have transposed the directive.
Well, thank you, Emmanuel. One of the things that's talked about class actions is the difference between the opt-in and the opt-out procedures. What is it exactly the difference between the two regimes, and which one, if any, does the European directive favor?
Well, that's indeed a very important concept in any collective action legislation. In an opt-in regime, the claim is brought on behalf of claimants who are identified in the proceedings and authorized the claim to be brought on their behalf. And so the claimants are not included unless they specifically opt into the proceedings. So that's the opt-in regime. In an opt-out regime, the claim is brought on behalf of those who are identified as members of a class of claimants, unless they take positive steps to opt out. And so they need to take some initiative to opt out, and then they are no longer considered as member of the class. And so it has huge consequences in practice, because it's a completely different way to compose the group of consumers who pretend to be harmed.
And does the directive provide for a choice between these two options?
No, it will be up to the member states to decide. And basically they have three options. They can choose for an opt-in regime, can choose for an opt-out regime, or, and that's the case in Belgium, it may be a combination, and the judge may decide, depending on the specifics of the case.
Thank you, Emmanuel. We can see that these actions may have quite an impact on companies themselves and their directors. And it's not only a matter for the executives, but board members should also mind, because even if their personal liability is not at stake, it's maybe an important risk for the companies, and risk control is one of the major functions of the companies. Fortunately, these issues can be covered by insurance. I'm now going to ask Nima, first, how do collective actions, and in particular the adoption of the new class action, will actually impact business and create risks into which you, insurer, can step in?
So the new directive obviously has the potential to increase the litigation risk in the EU. Consumers who wouldn't have the time or the means or the information to engage in litigation will now likely have that burden lifted. But it's important, and we mentioned some of those things earlier, it's important to remember some of the safeguards that are in place in the directive to avoid it being abused. And the first one is the loser pays principle, which requires the unsuccessful party in the litigation to pay the successful party's procedural costs. Differs a lot from the US, where each party pays their own costs regardless of the outcome. There's also a principle in place to prevent the possibility to judge the same facts involving the same parties twice. So it prevents the trader, from being sued in two jurisdictions by the same consumers. Also, many European countries today, they prohibit contingency fees for the plaintiff law firms, which essentially leads to the law firm having less incentive to take on a case and defend a class. This differs to the US, where the litigation environment is high, because there they allow for contingency fees, which is seen as one of the main drivers for the litigation frequency. So it will be interesting to see, what effect this will have on potential future consumer class actions. And then finally, to further prevent representative actions under the directive from being misused, punitive damages should be avoided. So qualified entities should also establish procedures to avoid conflict of interest and external influence. And that's namely, if you think about it, third-party funding or litigation funding. Again, if litigation funding will be prohibited, that differs a lot from the US, where litigation funding together with punitive damages are obviously seen as something that's driving litigation activity. So given the mentioned restrictions under the directive and the vast differences compared to the US rules, the directive is unlikely to usher in a new era of US-style litigation. It's also worth remembering that some EU countries have had mechanisms in place for allowing for consumer collective actions, but without, a lot of activity, although there's been some activity in certain countries. But I think with a clearer legislation across the EU, now we might see an increase in consumer class action litigation activity, but we will have to wait and see how the countries adopt this new directive.
Well, thank you, Nima. So you say that the litigation risk is somewhat limited, but however, it doesn't disappear. So how do you think that the new directive will affect the insurance or the insurability of these litigation risks?
So in the past, if you look at concerns for insurance companies that provide so-called directors and officers liability insurance, the main concern has not been shareholder or consumer class actions in Europe. Rather, concerns have been driving premiums have been around US-style litigation or US class actions. Even Australia and the UK have seen much more activity. And other type of claims, let's say in the EU, bankruptcy claims or claims related to regulatory investigations in connection with, let's say, an antitrust allegation, bribery or corruption, for example. Or internal claims. What I mean by that is claims between board members or between board members and management. That has mainly been what's been concerning for European insurers of directors and officers insurance. But with this new directive, it might lead to more activity on the consumer class action front in Europe. And if that happens, that will be another concern on top of the other concerns already mentioned. It might incur additional costs on the D&O insurance. At the very least, you can expect defense cost for any board member or executive that's named in the lawsuit. And that could lead to prices for D&O insurance going up. We will have to see about that. It's also important to say, just as a side note, in addition to concerns around consumer class actions, we've also seen a much more, evolving risks where there's much more focus and scrutiny around ESG and climate change related risks. And I think directors and officers today likely have more responsibility on their shoulders than ever before. I think it's important that you as a director or officer, consider what D&O insurance you have, what it covers and what it not covers, and to make sure that the limit of liability or the capacity that you buy is sufficient considering all the existing, but also all the new up and coming exposures that directors and officers will likely face in the future.
Well, thank you, Nima, and thank you actually to all three of you for these clarifications. It's obvious that although the directive will not be fully implemented by the member states before December 2023, which is the due date at which they must have achieved this transposition. And although there are a number of limitations to the litigation risk, and although there is probably not the need for much change in most of the existing legislations in the European Union, boards do have to look at these implications and to appraise the risks. And now is not too early. Thank you very much.